your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make your whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I fix you up for you.
Well, welcome to the show. Today is the Honorable Judge Vonda Bailey. So, it's like I said, don't get upset because I'm not interacting with you in the chat. I have to watch what's being presented to you because the ads have songs in them or music in it, and we'll get the channel struck. So I'm trying to keep that from happening. So I am watching what's going on. I do occasionally will switch back and forth. But it's like I said, I can't watch what's going on in the chat and watch what I'm being presented to you because I need to watch for ads. So let's go ahead and get this started. So let's share screen. Judge Vonda Bailey. Go back to StreamYard and make this bigger.
Got it.
Okay. So this case is now being live streamed from the court's YouTube channel. All right. Attorney Lovelace, you may proceed.
Yes, Your Honor. I pulled up the response and objection that I was going over before we discussed Mr. Wiegand. We had a dismissal date set on the 7th of July. We hadn't received a proposed decree from counsel, so I asked the coordinator to reset us. She reset us until August 4th, and it's on the court registry right now for August 4th. On July 11th, Your Honor, I was on vacation, and surprise, surprise, we had an emergency motion to appoint a receiver while I was on vacation. We had numerous emails with Judge Lee. On July 12th, we filed a motion to clarify, and the next day we got the proposed decree for the very first time. We've had it today for 11 days, and we had a hearing last Monday, the 17th at 11:33. We got the Word document. At that time is when we heard the appointment of the receiver, and Judge Lee told us that we would be having a clarification hearing today, a receiver hearing, and an entry hearing. At this point in time, Your Honor, as I sit here today, we have had the final decree for 7 days in Word where we can make revisions and edits. I understand the court wants to enter a decree today. I would respectfully request that we have appropriate time to review it and make objections. And for today's purposes, Your Honor, we have filed a motion to clarify, and we are simply asking that the court give us sufficient time and have a ruling on the clarification before a decree is entered. I will go to the motion to clarify as well, Your Honor. It is here before the court on the share screen. We have submitted everything on the motions and exhibits to both your court coordinator and your court reporter today, Your Honor. But here in the motion to clarify, we have some issues that we are seeking the court's help. Imagine having a state that's worth $1 million, but in the court's ruling, we're dividing $1.5 million. We have divided assets in excess of the value of the estate to make it a just and right division. As you look at the courts or at the motion to clarify, Your Honor, I've provided the court with a procedural history. And if you look down here, I want to walk you through the various issues that we're seeking clarification on. The first one being on the WRS Capital Partners, which was my client's company formed in 2008. The court confirmed this as his separate property here within the court's ruling. This is verbatim copied from the court's ruling. It says confirmation of separate property husband, portions of accounts, Bank of Texas checking account, Raymond James Investments, account 7251, James Sal and Company, Raymond James IRA, and WRS Capital Partners. It also lists wife's separate property down below. Your Honor, the amounts that we had going into trial for WRS Capital Partners, we had deadlines in which we had to exchange information. And I'd first like to point the court to the, let's see here, Exhibit 1. I don't know if the court can see this. Are you able to see that, Judge?
It's tiny. Is it the same thing that you filed with the court? If so, I can read from that.
No, ma'am. This is a exhibit that we emailed to the court and the court reporter.
Okay. Which exhibit is this?
It's marked as Exhibit 1.
Okay. I believe I have it from Destiny.
Okay.
Yes, I have it.
Okay. So we had deadlines which we were working from court, Your Honor. We had the deadline to exchange inventory and appraisements and property division spreadsheets. During that process, we had numbers that we used for the 3 or 4 months leading up to trial.
Your Honor, and at this point, I have to object to this line of argument or wherever. I don't know where counsel's going with this, but it seems like he's making an evidentiary objection about things that happened at trial or before trial, and we're here on a motion to enter. So I don't see how this is an objection, a proper objection to the court's memorandum ruling being accurately incorporated into the final decree of divorce. And so I object to this being irrelevant.
Your Honor, that's a talking objection. And I mean, if counsel has a legal objection, I understand, but I'd simply like to show the court some of the issues that we found. And
well, I object to relevance, and I object to reading from a document not admitted into evidence.
Sustain as to
summary that I prepared, Your Honor.
sustain as to relevance. I believe I made it very clear that your clarification will be treated as an objection. So the only things that I'm interested in hearing are your objections to the final proposed order. So we can go line by line, page by page, and actually looking at your objections to the order that was prepared by Attorney Bowman.
Yes, Your Honor. So I'll refer the court back to the motion to clarify that's on file with the court. You'll see there, Your Honor, that counsel provided us with a number in her inventory the night before trial for $920,499. Off to the side, it says offset by $156,500, which is H's portion of W's business. However, above it says WRS Capital Partners is husband's separate property. Your Honor, when we go down below that, you'll see on there that the court took the number that they included in their inventory and their spreadsheet. The numbers in the inventories and spreadsheet don't even match for one. That's what summary exhibit 1 was going to illustrate for you. But the court used the numbers from that. Similarly, the court included a number here of 250,000. That was a business within WRS. This number was counted as part of WRS. It was also counted down here in this line item and then divided. So we're seeking clarification on the value of WRS in the amount of RMS. That is the first point, Your Honor. The next point is various accounts were confirmed as husband's separate property. It doesn't specify amounts within the court's ruling, but separately in the spreadsheet. Of those, we have accounts with Raymond James, James Salem Company, and Raymond James IRA, as well as the Chase IRA 9437. There were numerous amounts. If you recall, Your Honor, my client married in 2013. We had an expert at trial that put on evidence as to the balances in those accounts as of the date of marriage. In the spreadsheet itself, Your Honor, this is the court's ruling. This is in the amounts that we've taken and copied and pasted into our motion so the court can see it. It's very small print here, but I just want to show the court what we've done. We've actually included as exhibit D portions of the court's ruling, Your Honor, and we've also put an interpretation in there, but nowhere in the court's.
I object again as to relevance, because I don't believe that counsel is objecting to anything that's specific that either the decree says or that Your Honor ordered. They're trying to basically redo the court's memorandum ruling, which is improper, in my opinion, and is not relevant to the entry of the decree.
Sustained. I'm not relitigating anything. I'm not reopening any evidence. This is specifically about the decree itself that was prepared by Attorney Bowman. And if you would like to share your screen with the order and go through and line item it, that's fine. But this order is going to be entered today. And
Yes, Your Honor.
As it comes up, then you can make your objection to what is in the decree.
Yes, Your Honor.
And I want to remind everybody, this hearing was set for 30 minutes. It's only 15 minutes aside. So however you choose to use your time is up to you. But Attorney Lovelace, you have 6 minutes and 33 seconds left. And Attorney Bowman, you have 14 minutes and 42 seconds left.
Your Honor, I appreciate that, but we weren't told at the beginning of the hearing how much time we had. Are we only having 30 minutes aside?
It's set for a 30-minute hearing.
We were never told that, Your Honor.
It's on the computer.
Okay. I won't argue with you, Your Honor. In terms of the issues that we have with the decree, if you look here, Your Honor, at the share screen, we submitted a red line decree as well as a clean copy. Counsel made certain findings that weren't in the court's ruling. On page 2, the language here, the court finds that third-party respondent defendant maintains a principal place of business, wasn't a finding that we made, and we simply just struck that. I don't think it will change anything substantially in the ruling.
Where are we looking at? Page 2 of where?
The decree that Ms. Bowman prepared, we've gone through and redlined the one that we received last Monday from our office.
Okay, so you're talking about that second paragraph at the top, correct?
Yes, ma'am.
Okay, Attorney Bowman, is there any objection to that coming out?
Yes, Your Honor. So as it relates to the court's ruling, of course, the court always anticipates the parties are going to put in language to effectuate the court's ruling. Jurisdictionally, the court, I have never seen a court enter any sort of finding in their memo ruling about jurisdiction over the parties. I think that's all standard language. Obviously, there is a third party respondent defendant that was properly served and that was part of this lawsuit. And so I think it's appropriate to include that same language about the third party defendant.
Okay. Okay,
I didn't hear what you said. Sorry.
The only testimony about the company was that he is the company and he's the one of those doubts.
That's right. And the only testimony about the company was that he is the company and his principal place of business and his residency is in Dallas.
okay. Well, the language will remain.
Yes, Your Honor. And I brought that up because your ruling says that WRS is confirmed as his separate property. So the court is taking jurisdiction over his, Mr. Tremy's separate property in here.
And the court also on that memorandum found that it was a mix. Portions of WRS, the court did find was Mr. Shramy's separate property, but there were also portions that the court found to be community. So it was a mix.
Okay.
The court didn't find that it was 100% his separate property.
I understand, Your Honor, but the court didn't confirm in its spreadsheet ruling that any of it was his separate property either.
Yeah, you can see the breakdown on the, what do you call it, on the spreadsheet.
Do you mind pointing it out to where that would be, Your Honor?
It's on the spreadsheet. It says WRS Capital Partners LLC value at $920,499.
But
Husband,
what portion is his separate property?
it's right there on the spreadsheet. I'm confused by your question.
Right. And I object to relevancy also, Your Honor, because at this point, it seems like counsel's questioning the court and not properly objecting to the language of the order. And I do think that the language of the proposed order accurately incorporates the court's ruling in regard to WRS.
Okay, sustained.
Okay. And that's part of my question, Your Honor, is I'm trying to interpret your ruling to make sure we make the proper objections in the decree. And there's nowhere in here that says community or separate in the court's ruling on the spreadsheet.
And again, Your Honor, I think
It's
that
on the court. It's, just to be clear, it's on the court's memorandum. I'm not reopening any evidence. Once we get to that portion and you need to clarify what is in the order, the proposed order, then we will clarify it at that point. But right now, I believe we're on page 2.
Okay. Your Honor, if you go down, it's just a typo. His name is Will, not William, on page 6.
and no objection to that, Your Honor. I've already made that change.
Okay, is this under the right subject to the agreement of both conservators?
Yes.
Yes.
Okay, I have made that change.
Down here, Your Honor, I think counsel included language that wasn't in the
Down
MSA,
on what page? What page?
page 9. The parties actually agreed to all SAPs or issues at mediation. And it looks like they just adopted language that wasn't included.
Well, actually, Your Honor, the holiday possession was in the pretrial stipulations that we filed with the court. And so that's separate from the mediated settlement agreement. So I did incorporate the language that the parties reached as far as stipulation on holiday possession.
Okay, I remember the stipulations. Is this not the appropriate outline of it?
No, Your Honor. It's Ms. Ramey's interpretation of it. We just struck some of the language as to the dates and times of when they started. They're not significant changes either.
Well, I think the significant part would be rather than it being the Thanksgiving holiday, respondent's version says that it would just be Thanksgiving Day for the Thanksgiving holiday.
What the court did, it says the court adopts the stipulation of issues between the parties as outlined on May 30th, 2023. So I don't have it in terms of what you all said. I just adopted whatever the agreement was. So what should it actually, instead of Thanksgiving holiday, should it say Thanksgiving Day?
I can pull up the stipulations, Your Honor.
Yes, I have it up right here too, if that's helpful.
Yes, so just so we're clear, we are at Christmas holidays or holiday position, right?
Yes,
Thanksgiving.
Okay. So number 3 and number 4.
yes.
Okay, what was the stipulation for Thanksgiving?
I'm pulling up the stipulation, Your Honor. We have here Thanksgiving Day. And here's the exact language from the stipulation that we agreed to.
You'll have to read it because that is like size 4-inch font.
It just says the parties will alternate Thanksgiving holiday every year, mother to have odd numbered years and father to have even numbered years.
That's what this order says that I'm reading.
It says Thanksgiving Day.
What's that?
I believe my client, Your Honor, I'm sorry.
Okay, Mr. Schramme, you can't speak out. Your client would actually, your attorney would actually have to do the speaking for you. My court reporter has to keep up with who's speaking. I don't want to mess up your record.
Yes, Your Honor. And it just says right here, Thanksgiving Day in section 10B. It doesn't say the whole Thanksgiving holiday.
Okay, so it should read, in odd number years, mother shall have the right to possession of the children, beginning at the time the children's school is dismissed for Thanksgiving Day.
That's what the stipulation says, Your Honor.
Your Honor, this is Mr. Bowman. He's not accurate. The stipulation title for that section is Thanksgiving Day. The actual provision says the parties will alternate Thanksgiving holiday.
And Your Honor, I'm happy for one attorney to present. I know the court reporter is trying to keep track of everything.
Holiday
Okay,
is one day.
okay, so, Mr. Lovelace, was that you? Or was that your client again?
That was Mr. Bowman, then
Mr.
me.
Bowman, okay, I can't, so you all have to, if, Attorney Bowman, Lacey Bowman, if you like to mute and Mr. Bowman say things and then you, say it out loud, that would be great. It's just, I can't even keep up with who's speaking.
Yes, Your Honor.
Okay. All right, so let me make sure I'm reading this right. The children's school is dismissed for the Thanksgiving holiday, because Thanksgiving Day just wouldn't sound right because they're not dismissed for Thanksgiving Day per se.
Correct.
I'm just reading the stipulation, Your Honor. It says Thanksgiving Day.
I understand, but you want something that's enforceable for your clients, and writing Thanksgiving Day is, if there's a dispute, there's no way for anybody to enforce that.
We would ask that the language reflect the changes that we submitted.
And Your Honor, it's just, for me, our response is just, we think it says Thanksgiving Day, the parties will alternate Thanksgiving holiday every year. So I do think, and mother to have odd years, father to have even numbered years. And I think it would be a stretch to say that agreement meant just the actual day of the holiday, because then you run into issues with family and when do we exchange, and a lot of back and forth for the kiddos. And so I think the agreement of the parties was to alternate Thanksgiving holiday, just like it says.
It says Thanksgiving Day, Your Honor.
Your Honor, this is
Thank you.
Will Schramme. Can I say something, please?
Oh, you may not, Mr. Schramme. If you speak out again, I have no choice but to remove you from the hearing.
Fair enough.
I guess for enforceability purposes, I'm trying to see the best way to effectuate this without changing the agreement of the parties, because it says we may have to change that entire paragraph altogether then, because it says shall have the right of the children beginning at the time school dismisses for the Thanksgiving holiday and ending at the time the children's school day resumes. So we need to change that. If the agreement between the parties was to only do Thanksgiving Day, then it needs to change to, at the beginning, the child school is dismissed for the Thanksgiving holiday, and something to say only for that day. But there needs to be some clarification on how exchanges are going to be made, what time, everything like that in order for it to be enforceable. So we would have to tweak that a little bit more. I understand the agreement of the parties, but as law practitioners, you all have to further explain what that looks like for enforceability.
Yes, Your Honor. The reason we did it that way is because we have a 2-2-3 possession schedule. It's father has Monday, Tuesdays, mother's has Wednesday, Thursdays, and they alternate weekends. So that's why we carved it out differently than what we normally would do with a standard or expanded standard possession schedule.
Your Honor, I disagree with Mr. Lovelace's interpretation. It is our position that the parties meant to alternate the Thanksgiving holiday, which is why it says we'll alternate the holiday. Just like with Christmas, when we had a unique Christmas situation, we had specific beginning and ending times. And so for Thanksgiving, we just have the standard language there because it was the intent of the parties to alternate the actual holiday. So if you look at little paragraph A above, or I'm sorry, paragraph 1 and 2 above, you'll see that we did carve out specific beginning and ending times for Christmas because that was a unique custom Christmas possession schedule. Whereas for Thanksgiving, we did not do that because it was the intent to alternate the actual entire school holiday.
And I disagree wholeheartedly with Ms. Bowman. That was not our intent. The stipulation says Thanksgiving Day. It doesn't say holiday.
So then that means that Thanksgiving needs to mirror Christmas. So what times are we choosing for Thanksgiving Day?
We have in here with our changes, Your Honor, 9 a.m. and ending at 9 a.m. the following day.
And
Okay.
that's not agreed to by the parties. And Mr. Lovelace keeps saying Thanksgiving Day. The stipulation says the parties will alternate Thanksgiving holiday every year.
Could you pull this?
Yes, sure. If I may share screen, I have it open in front of me.
Yes,
Unless-
Attorney Lovelace, would you stop screen share?
Certainly.
Thank you. Attorney Bowman, go ahead.
Yes, Your Honor.
And you'll have to enlarge it.
Oh, yes. Okay. Let me try that.
And this is our point, Your Honor. It says Thanksgiving Day in section B, whereas above it says Christmas holiday. So we didn't use the same language.
So, Your Honor, I mean, the substance of this paragraph would prevail. The parties will alternate Thanksgiving holiday every year. We did not put in any unique pickup drop-off times because they were to alternate the actual Thanksgiving holiday. If we had meant to carve out a specific day, we would have done it the same way we did in paragraph A above, where we had custom pickup and drop-off times.
Okay, so the court is going to adopt the language as it's written because it specifically says here on the stipulation, the parties will alternate Thanksgiving holiday every year to have odd number years, for mother to have odd number years, and for father to have even number years. And that's exactly what the order says.
Thank you, Your Honor.
What is the next objection?
Your Honor, the next objection is on page 12. This was a case that had no child support. So we simply just put the standard paragraph title of child support to reflect that they're not substantive changes. And then we put medical expenses down below since everything appeared to be grouped together.
Okay, so are you referring to the meeting the children's financial needs section?
Yes, ma'am.
Are you saying that it needs to come out?
Do you happen to have our red line version of the decree, Your Honor?
I'm not reading from two decrees. I want you to make the objection and then I'm going to make the
I
change.
understand. This just red lines their decree so you can see our changes so we can jump directly to all the changes.
Right, but for purposes of making this record that you requested, I'm asking that you read it out and then I would just strike as you all go.
So I'm happy to. And page 12,
Okay,
they put meeting the children's financial needs. In our red line version, we cross that out and we simply put child support. And then in that paragraph, it says it is therefore ordered that neither party shall pay child support. And we crossed out to the other party except as specifically set forth herein. And that's just verbatim from the mediated settlement agreement.
Okay, so what the court will write is that the parties agreed and it is therefore ordered that no child support is to be paid by neither. There is no child support obligation between neither parent.
Correct.
Yes, Your Honor, Ms. Tramey was asking for child support at trial, but we believe based on the division of the estate as ordered and the court's findings there, that there was no child support ordered. And so that's just that's standard language that I use. I'm not saying it's standard language everyone uses, but when there is no child support. So that's why I called it meeting the financial needs of the children.
Yeah, I think that is wordy. We can just say it is ordered that there is no child support obligation between the parties.
Yes, Your Honor.
And that's what your ruling says, Your Honor. And then we added medical expenses down below that for the next paragraph, Your Honor.
And I'm
Okay.
not sure why they did that because those aren't medical expenses that come underneath that section. The medical expenses come later down under medical support. And so I don't think we should add that header in above extracurricular activities and tutoring. That part.
I'm happy to just put additional expenses there. That makes it easier, Ms. Bowman.
It would make it accurate.
Yeah, it's just you all grouped it as child support in the child support section. So I just wanted to differentiate.
Okay,
Well,
talking about that paragraph that's under speech therapy.
It's sections 1, 2, 3. They're all grouped, but there was no title for that. So additional expenses for the children would be fine.
So so under child support, I have that one line, and then you saying there's no heading above where it says the court finds the following orders are in the best interest of the children.
I pulled it up on my share screen, Your Honor. It's
Yeah,
the bottom of
Mr.
page.
Lovelace, that is really, really small. If you want me to see that, you're going to have to enlarge it.
Yes, ma'am. Is that better, Your Honor?
Yes. Okay, so you're saying you labeled it medical expenses.
Yeah, and I'm happy to put additional expenses for the children.
Okay. Just so it can have a heading, I understand. I entitled it additional expenses for the children.
No objection, Your Honor.
Okay. All right. Okay, that's done.
May I go to the next point, Your Honor?
Yes.
Okay. My client didn't have his information in here, his email address or phone number on page 14. We simply added it.
Okay, can you read it out?
Yes, ma'am. It's W. Schramme, his last name at yahoo.com.
It's CHRAMME. You said Yahoo?
Yes, ma'am.
Okay, and his phone number too?
It's 214-679-1195, and I have it on the share screen for you as well.
Okay, I've made that change too. Okay.
We do not have any other changes until you get down to the property section, Your Honor.
Okay. Hold on one second. Just for clarification purposes, there's a hanging header from me moving the document. So I just pushed it down. I just didn't want you to look for it. It says, hold on, let me re-add it. Oops. It's the provision of dental coverage. I just pushed it down.
Okay.
Okay, so what page are we on now?
We are on page 24, Your Honor.
Okay, I'm there.
Your Honor, in your ruling, you made a statement that husband shall either sell or refinance the residence located at 3143 Harvard, Dallas, Texas, no later than December 1st. Council filed a request for a receiver last week. This is the house that Ms. Schramme is currently living in. This is a house that my client is paying the mortgage and utilities on and has been since September 2022. We don't have a move-out date from the court. And at this point in time, Your Honor, they had included language in here about a money judgment on the house. We simply struck line item 1 and awarded him the house because that's what the court referenced. And then we included the money judgment section down below.
And yes, Your Honor, I don't know what the objection was there, other than the way we worded it accurately incorporated the court's ruling, because the award of the house was subject to husband paying the cash money judgment to wife. So that is why we worded it the way that we did. It wasn't just an unfettered award. It was subject to the payment or the cash out refi or the sale of the house with the aid of the receiver. And we did file, and counsel keeps referencing the motion for a receiver. We did file a motion for appointment of a receiver since
An emergency motion.
an emergency motion, since husband has missed his deadline and bills were needing to be paid and texts were being sent from husband to wife about that. So I know we probably don't have time to hear all of that today, but I didn't know if that was something that the court's already reviewed, in which case we do have an order ready to be entered on that as well. But as it relates to that rewording of our decree, I believe our version more accurately incorporates the court's ruling.
And Your Honor, we all thought it was just duplicative. Down here it says subject to the money judgment ordered to wife as set forth herein. So we kept that language in there. The portion below, it references it twice.
Okay, so you're saying is the first portion should be crossed out.
Yes, ma'am.
Okay, let me see. So this is. So let me see, the Harbor residence located at. Okay, so you just wanted to start at the Harbor residence.
Just, yes, ma'am.
Okay, and then the money judgment is below Attorney Bowman?
There's a whole
Yes,
separate
Your
section.
Honor, I had a section entitled money judgment secured by Harvard residents, just so everything was clean and easy to be cross-referenced. And so I think the language that they added is a little bit more loosey-goosey. So otherwise it doesn't make sense. Why would they care if we start with one or end with the other? But they did specifically take out subject to the provision entitled money judgment secured by Harvard residents. So perhaps that's why they did it. But regardless, our language is accurate. And so I don't see the need to just reword it because husband wants to reword it.
I guess I'm trying to follow Mr. Lovelace. It's referencing down below. So does it hurt to keep the language?
It's duplicative, Your Honor. The section 1 addresses the award of the Harvard house. It says subject to the money judgment ordered to wife as set forth herein. If you go down to the language below, there's an entirely separate section dealing with the money judgment.
Right, but I guess what I'm trying to say, does it make the order any less enforceable if it's in there? Or does it change it at all?
It's just something that we're trying to make it as clean as possible. And when you have the same paragraph appearing twice, we thought it was duplicative, so we crossed it out.
Okay, because maybe I'm missing something because I don't see it as written a second time. I just see it referencing something below. It's not necessarily repeating the exact same paragraph.
Okay. I'm just looking at the red line version that I have on the share screen, Your Honor, instead of going through several different versions. I'm sorry.
Okay. I don't see the need to change it. It doesn't change anything that's written below.
Okay. So how do you want us to handle this issue?
What they have is fine in their order.
Okay. I'll go to the next one, Your Honor.
Okay.
Your Honor, you confirmed certain accounts as my client's separate property. And as I mentioned in the spreadsheet, they're referenced as his separate property. They've included all of this here in the community property section.
What page are we on, Attorney Lovelace?
Well, we're on page 25 of the red line version I'm looking at on the share screen.
Okay. You're on section 4.
Section 4.
So what's the objection?
Whenever I prepared a decree in my 20 years of practice, I've always included a community property section and a separate property section, Your Honor. And I've identified what portion is separate and community. My objection is this is all listed in the community property section. We need to differentiate what is community and separate. That does not do that here.
Okay, Attorney Bowman?
Yes, Your Honor. I guess, I think paragraph 5, I don't know, they just crossed out some paragraphs here, so I guess I'll start with that. There was a cash payment ordered for wife's benefit in the amount of $303,750. And the remaining assets and values of WRS we awarded to husband. And so I think it's necessary. They crossed out paragraph 5 and didn't put it back in any other way. And so I object to that because it was the court's ruling to award wife a cash payment in that amount related to the value of WRS Capital Partners. I'm
sorry, is that why number 5 is missing on your decree?
Yeah, I think that's why number 5 is missing on theirs. If we look at our version,
Because I see yours is 4, 6, 7, 8, 9, 10. I don't see a number 5 at all.
Really? Let me make sure we sent you the right version. That's the version I'm looking at.
Are we looking under husband or are we looking under?
I was looking on page 24 of our decree.
Oh, the bottom of page 24. I have it.
Yes. Okay, perfect. Okay.
And Your Honor, I'm noticing some difficulty on my part, at least, of identifying what pages and sections we're looking at. I'm more than happy to have an in-person live hearing so that we can walk you through and show you the exhibits if that helps the court at all.
It doesn't. Only thing because as you all speak and as changes are made, I just type it in.
Perfect. Your Honor, and I think Mr. Lovelace is looking at his red line version, and so that could also be why he's confused, because I think we're looking at the original decree. So if we look at the original decree that we drafted, page 24, line item 5, husband's red line version just struck that out, and then he's arguing about retirement accounts, which the court's ruling specifically identified all of those, all of the assets, and divided a portion of it to husband and a portion of it to wife. And so I believe that our paragraph, oh, that is another paragraph 4. That is weird. I see what you're saying now. I don't know. So that should be paragraph 6 for retirement funds. Sorry about that. I see the confusion now. And so those are the exact sums. If you look at the court spreadsheet, I just took those same sums of money and I awarded those to husband.
And I guess this is my confusion, Your Honor. In the court's ruling that I went through earlier, it says the accounts on page 2 of 4, what is confirmed as husband's separate property. And it says Raymond James Investment 7251, James Sound Company 6817, Raymond James 2106, and portions of other accounts. Here on the court spreadsheet, I still am having difficulty understanding where it's confirmed what portion is separate and what portion is community. And that's why we crossed that section out, because usually we list separate property in an entirely separate section in the divorce decree, and counsel has lumped everything together.
Well, as long as it is in compliance with the court's order, I don't necessarily think that is wrong. It's just a matter of you all doing your drafting styles are different. But from what I'm looking at with the court spreadsheet, with the also with the memorandum, just to make sure that I'm cross-referencing, it doesn't look inaccurate. It looks like it's aligned with the court's ruling.
Well, Your Honor, the court's ruling also says 54% to husband and 41% to wife, which is about 95, 96%. And I'm still having difficulty understanding on this spreadsheet that the court prepared, where is the separate property section that was awarded to both parties from the accounts? And that's what I'm trying to understand.
Okay, so what is your objection to that section? Is in terms of how it's written. I'm not getting into the substance of anything. In terms of how it's written, is it wrong from the court's ruling?
I don't know, Your Honor, because it doesn't specify in the court's ruling as a community or separate. So my objection is we need to have the accounts separated into community and separate in the decree to specify who was awarded what portions of the accounts and confirm what is separate.
Okay,
Oh, sorry.
go ahead.
Oh, I was just going to say, Your Honor, I think that the court's ruling specifically addresses what's awarded to each party. And once that award is made to each party, then it is confirmed as that party's separate property, once that community property is divided. And certainly while Mr. Shrami had his own version of spreadsheets, that's not our version, nor was it our expert's version, nor was it the version that the court ultimately used. And so I think that our paragraph 6 for retirement funds does accurately incorporate the amount of those retirement accounts that were awarded to husband.
Okay,
Your Honor, go ahead.
no, go ahead.
Your Honor, in no spreadsheets or inventories does Ms. Bowman ever confirm any separate property of Mr. Shrami. She doesn't even list her client's mineral interest here on the screen. The problem is all along throughout this case, my client had about $1 million worth of separate property that we were asking to be confirmed at trial. And that's all I'm trying to do is confirm what the court's intent was as to my client's separate property.
And I don't believe that's proper. If you want to confirm what the court's intent was, that's on a findings of fact, conclusions of law. This is simply to enter the order.
Well, speaking of, Your Honor,
You may not agree with the court's ruling, but in terms of how the court wrote it, the court was just asking Attorney Bowman to put an order together that was pursuant to the court's ruling, not whether or not there was an agreement to it. So at this point, the court is just trying to get the order entered. And then at that point, as I stated, any findings of fact, conclusion of law, you're more than welcome to do that.
okay. May I ask one question, Your Honor?
If it's related to this order, I mean, because I don't want to spend a lot of time entering the order. It's not necessary.
Yes, ma'am. So if I were to just say this category of my client's 401k for his company that he worked at prior to marriage in 2013 when they got married, what number should we put in the separate property section confirming the amount?
And Your Honor, I think that's an improper question for the court because again, that's a findings of fact issue. I think the court, obviously, we didn't include any as his separate property because we didn't think he could clearly trace it. And his expert admitted he didn't have the documents. And so I think asking the court at this stage of the game to tell you on the record what the court's position was on that issue is improper. And I think that the spreadsheet's clear as far as what was awarded to husband and what was awarded to wife.
Sustain. You may move on and tell me what portion of, not necessarily whether you agree with it or not, the writing that's there, does it conform with the court's ruling? If the answer is yes, then we'll move on to the next section, not whether or not you agree to it.
I don't know, Your Honor. I don't understand the separate property section and the portion here in the ruling that we put on here. I've struck it because I don't understand it, and I'm sorry.
Okay, no problem, no problem. The language will remain. Okay, what's the next objection?
Your Honor, we both submitted property division list and the court made a ruling of property division, but Ms. Schramme is currently living in the marital residence on Harvard. And we don't have anything attached as to the property to be divided between the parties.
And Your Honor, my response to that is the court specifically said when husband moved out, there was testimony about items that he took or things that he may have purchased. And the court specifically said husband's awarded what's in his possession and wife's awarded what's in her possession, which is pretty standard. And in a state like this, I doubt the court would want to get into the pots and pans types issues. So I think it's very clear in the memorandum ruling where it says all property in husband's possession is awarded to husband, all property in wife's possession is awarded to wife.
And I appreciate Ms. Bowman elaborating and interpreting to her own benefit, but I'm looking at the ruling and it doesn't say that anywhere, Your Honor.
Under property issues at the bottom of each, it says all other separate personal property in husband's possession, all other separate personal property in wife's possession. That was the confirmation of their separate property. Is that what you're referring to?
That's what I was referring to, Your Honor.
It's there.
Okay, so each party had spreadsheets that we submitted at trial. Ms. Bowman had submitted one and I submitted one. Ms. Schramme is currently living in the Harvard house. I don't know if she's supposed to remove all the furniture and items from the Harvard house into her university house or leave it there. We're fine if she wants to leave everything in the Harvard house. That house was awarded to my client.
And Your Honor, again, that's not what the court's ruling says. What's in wife's possession, which is where she currently lives, was awarded to her. What's in husband's possession, which is where he currently lives, is awarded to him. And I believe that's accurately incorporating the court's ruling.
And I also put on here confirmation of separate property, household property items set forth on Exhibit 1A. I believe that's what wife submitted. So that's the personal property that the court was referring to.
Okay,
Yes,
Your Honor, my client is currently living with his father in his father's house, and my client has no furniture or property in his possession because it's all in the house where wife is living.
Okay, well, wife is only entitled to what was outlined as household property items on Exhibit 1A. Anything outside of that wouldn't be included. That would be what remains in the home.
If you look at their 1A exhibit, Your Honor, it basically allows her
I'm not going back into the evidence. I just admitted what the court's memorandum says. Household property items set forth on Exhibit 1A.
Okay. Does the court take into consideration any property in husband's possession?
The court made its ruling and put all separate personal property in husband's possession.
Okay. I just want to make a formal request. Is the court denying father's ability to have any of the furniture or personal items from the Harvard house which he is awarded?
The court is not answering that question because the court made its ruling.
Okay. Would it be too much trouble to attach an exhibit to the decree as to the property that was awarded to each person?
I believe attaching anything to the decree reopens evidence and gives the other side an opportunity to relitigate, and we're not relitigating any issues.
Okay.
Okay, are we still on page 25?
Yes, Your Honor. In section 10, I crossed out all investments in closely held business interests in husband's name or entity wherein husband has an investment ownership interest that are not otherwise specifically divided herein, save and except the $125,000 money judgment awarded to wife to represent wife's portion of the same.
Okay, is that on your red line copy?
Yes, ma'am.
Okay, Attorney Bowman, which page, where are we looking on your order? Because that's the only one I'm referring to.
Yes, Your Honor, we are looking at paragraph, it's on that same page we were just looking at. It should be paragraph 11, but those numbers had gotten off. You'll see the Toyota 4Runner, household furnishings, jewelry, club memberships, and then under that it says all the investments in closely held business interests.
Okay. And Mr. Attorney Lovelace, in regards to that paragraph with the memorandum, does it not conform to the court's memorandum ruling? What is your objection to that if it does not?
My objection, Your Honor, is that counsel has listed Rencheck Marketing Services / RMS in 3 separate places on their inventory, which the court adopted. So the court is dividing a property or a business that my client had 3 separate times. So this is allowing Ms. Shrammy
I object
to
to
double and
relevance
triple
because I
dip
believe
on the
that counsel,
monies.
sorry, objection to
Uh,
relevance.
This,
Because
this-
I believe counsel is going outside of the memorandum ruling and is now trying to relitigate the valuation or inclusion of assets, which isn't the purpose of the entry hearing.
Correct, sustained. Attorney Lovelace, does number 9, and listen to my question. Does number 9 conform to the court's memorandum ruling, yes or no?
I don't know, Your Honor. It says Exhibit M2, Inventory 6. It does not specify anything other than that.
Okay, I think you may want to refer to Attorney Bowman's copy, because that's only, I'm not entertaining your red line. I'm allowing you to read them into the court's record as objections, but I'm only looking at one decree. And the decree that I see is number 9, all the investments and closely held business interests in husband's name and or entity wherein husband has an investment / ownership interests that are not otherwise specifically divided herein, save and accept the $125,000 money judgment awarded herein to wife to represent wife's portion of same. What is your objection to that in terms of it being in compliance with the court's memorandum ruling and spreadsheet?
Your Honor, I was told that my clarification would be as objections, and so that's what I'm trying to do is make a record of my objection. WRMS is listed in several different places on the court's ruling and in Ms. Bowman's inventory and spreadsheet. And what I have here on the share screen reflects that. It has WRMS up top, down below, and within WRS. So my simple objection is as to the interpretation of what she referred to in her decree as reflected in the ruling, which is right below WRS Capital Partners.
Okay, so are you referring to investments in, the court did a shorthand of CHB? The closely held business, that's correct, right?
Correct.
That's in alignment with the spreadsheet, so the court is going to accept that language.
Okay.
What is the next, what page, which paragraph?
The next page, Your Honor. Is property to wife, Your Honor.
Property to wife, okay, which number?
Here you've listed, or counsel has listed the same thing that I just made the objection to is the 125,000 in section 5.
Okay,
It's
I've
the
already-
same objection.
okay, I made a ruling on that one.
I know, and I'm just going through each line item, Your Honor, so we have a record of it.
Okay,
Number 7, Your Honor, is the same objection as before as to the amount as the WRS Capital Partners.
okay, that language will remain as well. I'm just cross-referencing with the spreadsheet.
Okay. And number 11, Your Honor,
I believe we addressed number 11. That language will remain as well.
okay. For purposes of interpretation, Your Honor, I'm reading the ruling and my clients asked for me to ask for clarification. It says if husband fails to pay the amount as ordered by the court, husband shall either sell or refinance the residence located at 3413 Harvard, Dallas, no later than December 1st, 2023. Last week, council filed an emergency motion to appoint a receiver. I think the court's intent was to give husband some time in which to pay that money. My client has been in discussions about securing a bond to pay the amount as ordered by the court. But I don't see anything that justifies filing an emergency motion based on the date listed there of December 1st. And council appears to have put that language regarding December 1st way down here towards the bottom. And so I would simply ask that if that was the court's intent, that we be provided sufficient time as set forth in the court's ruling.
The court's intention was to have Mr. Shrammy pay the $699,293.61 as Weiss community property no later than July 7th.
Well, Your Honor, he's been paying the mortgage and utilities since your ruling on June 8th, him by himself.
I understand, but that wasn't the court's ruling. The court's ruling is, as I just stated, he was ordered to pay this sum of money by July 7th, no later than July 7th, 2023 by 5:00 p.m. And
Okay.
if he didn't pay it by that date, he shall either sell it or refinance the residence no later than December 1st of 2023.
Okay. For purposes of in understanding the December 1st date, what is that date and how should it be included in the decree?
That's the date that he should either sell or refinance the house by.
I understand, but council has filed an emergency motion last week seeking to sell the house or other assets. And I just want to make sure we put the brakes on things and give him time to comply with your court's ruling.
The court has not addressed or entertained any motion for receivership.
Okay.
Nor does this point one, Your Honor. I think this language accurately incorporates the court's ruling. He has to pay it. If he didn't pay it by July 7th, he has to obtain the money either through a cash out refi or selling the house by December 1. And we would like to eventually set that motion on your docket, Your Honor, because it's our understanding that he is not intending on obtaining that money through.
Objection is to hearsay and relevancy, Your Honor.
The court will sustain as to relevancy because we're not at the point of receivership. I understand that it has been listed in the decree for completion purposes. However, we're not at that step. We're just entering the order, excuse me.
Yes, Your Honor.
Okay, so the language is written will remain.
Okay. And I'm looking here, Your Honor, they've included a bunch of language in paragraph 2 about then a receiver shall be appointed as to the Harvard House. And I'm trying to make sure that tracks your ruling. And I don't think that it does.
Refinance the residence located at 3413 Harvard.
On the section 2, Your Honor, they put if husband fails to pay that amount, then they added language in there that a receiver shall be appointed as to 3413 Harvard, Dallas, as set forth here and below in the provision entitled money judgment secured by Harvard residents and is so ordered. And I'm not seeing that in your ruling. If Ms. Bowman can point it out, that may help.
Well, that's what I just said. She put that in there for completion purposes in the event that the home is not, Mr. Shrammy does not pay the money or the home is not sold. I think that it looks like that was the reason that this was put in here.
Well,
Yes,
I would
sir.
object to that entire paragraph then if it doesn't reflect the court's ruling.
But it does reflect the court's ruling. The memorandum is just a loose written outline of what the court puts on the attorneys to further put into the order to make it enforceable as well as complete. So it is still in alignment with the court's ruling.
Okay, Your Honor. So I've noted my objection as to this paragraph at this point.
Okay, what is your next objection?
It says it is ordered that husband shall be responsible for any cause fees related to the receiver, and that husband shall timely pay the receiver for services rendered pursuant to the requirements of the receiver. We would object to that section as well.
And Your Honor, I included that language to effectuate the court's ruling because I believe that the receiver will most likely want to get paid, and should there be one necessary, it would be because of husband's inactions or non-compliance with the payment schedule. And so to that end, it would make sense as an extension of that for husband to have to pay the cost of the receiver.
Well, that portion, the court didn't necessarily say that husband should necessarily pay it. Let me make sure I'm reading this. We're on, is this paragraph?
The last paragraph.
Responsible for. Well, I mean, if husband is the reason why the receiver is appointed, I mean, it would make sense that he pays it. Do you disagree, Attorney Lovelace? Because I believe it would be unfair if Mrs. Schramme has to pay it and she's not the reason the receiver was appointed. She's just trying to get a payout.
And I understand, Your Honor, and I think the court will remember that testimony was provided at trial that neither party had significant cash assets. They had 2 houses and 2 businesses, but the most money in any bank account wouldn't even cover $50,000. They had retirement accounts. And so anything that my client would have to pay would certainly not be intentional. It's, does he have the ability to cash out retirement accounts or 401ks or anything else? We certainly didn't want to suggest doing anything until we had a decree. And as I went through earlier on the accounts, Your Honor, in the court's ruling, I tried to identify that the 401k accounts and the SEP IRA accounts, they're all tax affected. So if he has to pull money out in which to pay Ms. Schramme the judgment, it's not a dollar for dollar amount. And so that's not something. I have clients that are obstinate or that don't do things so that the other person doesn't get money. And that has not been the case throughout. As I mentioned, my client's been paying the mortgage and utilities for Ms. Schramme to live for free for the past couple of months.
Okay, well, none of that is relevant in terms of what we are discussing right now at this moment. I understand why the language was put in there. Although the court did not order it, if we're going to address any objections as your clarification, I don't see why husband should pay 100% for the receiver if he's the reason why the receiver is being placed on the case.
Your Honor, I understand. I'm just trying to make points of my motion to clarification that was set today based on the email that Judge Lee sent me. So I'm trying to make sure the court's aware of our points throughout.
Okay, no, the court understands and I understand it. Yeah, I don't see why the language shouldn't remain, because as I stated, it will be punishing Ms. Schramme when all she's trying to do is get a money payout. So if a receiver at the time that that is entertained does have to be appointed on this case, it would only be just and fair if Mr. Schramme would be responsible for those costs.
Well, right now, Your Honor, as I mentioned, both parties, they have 2 houses. One of them is a rent property. The court didn't specify a date in which Ms. Schramme has to move out of the Harvard house. We would ask for that today if the court's so inclined.
Well, and Your Honor, I think that would be a separate motion where the court would hear our receivership issues because
It's in our motion to clarify, Ms. Bowman.
well, in Your Honor, I'm sorry, but it also is related to our receivership motion because Ms. Schramme can't afford to move out and take on these expenses until she gets the cash judgment, but Mr. Schramme is refusing to pay her that or any of that money. And so I think that's a more complicated question that we may have to work out at the time of a further hearing, but it wasn't in the court's ruling, and therefore I don't think a deadline to move out would be appropriate currently, given the fact that Mr. Schramme did not pay the money that he was ordered to pay, nor has he, to my knowledge, taken steps to obtain that money through the mechanisms that are provided.
And I mentioned that he's in the process of trying to secure a bond. And just to reiterate, my client lost his job this year, Your Honor. Ms. Shremmy makes more than he does, yet he's the one paying all of the costs for both houses and the utilities. And we're simply
Your Honor, I object
asking
to
for
that.
what we've set forth in our motion to clarify regarding a move-out date.
Okay, so we are on, so just to be clear, I've already made the ruling that the language will remain. Are we on page 28?
We're on page 28, Your Honor,
Okay,
or actually 35, the confirmation of separate property assets of petitioner.
okay. Okay,
None of these, the court already said that they didn't want to include what I understood to be Exhibit A1. None of this is listed in the 7 household property items. None of that's been confirmed as separate property, and I just asked that all that be struck.
okay, and the court just referenced, let me pull the spreadsheet up. I mean, not the spreadsheet, the memorandum. The court just referenced household property items set forth on Exhibit 1A. Now, if these are the specific items, are these the items that were listed on Exhibit 1A?
Yes, Your Honor.
If these were the items listed on Exhibit A, then the court doesn't see a need for it to be removed.
Well, would it be possible to add Exhibit 1A to the decree and remove this section?
I mean, I guess it's possible. I don't see
That's what
why.
we would prefer.
Okay, Attorney Bowman, do you have any objection to that? Just attaching the, what do you call it, the spreadsheet of 1A, the exhibit that you used during trial, and just attaching it and reference. I can say, I'll change it. The item set forth on Exhibit 1A, Mother's Exhibit 1A.
That's fine, Your Honor. I don't have a problem with that.
Okay, so that's what the court will do. The court will modify that language to say household. Just copy and paste the whole portion. And then what I'm doing is literally copying and pasting what memorandum said, household property items set forth on Mother's Exhibit 1A, and I'm deleting all of the list.
Yes, Your Honor.
Okay. And I put an and after the semicolon just to close that section. Okay, so that is, there's nothing else on page 35 now.
No, ma'am, that's correct.
Okay, all right.
And then similarly, we would add the reference to 1A in father's separate property assets.
I don't understand that because that wasn't in the court's memorandum ruling, so we would object to inclusion of 1A as his separate property, since that wasn't confirmed as a separate property in the court's ruling.
Yeah,
And I'm just, go ahead.
the only thing the court put in husband's separate property is his engagement, band, portions of accounts. And so portions of accounts is italicized, and what's underneath it reflects the portions of Bank of Texas checking account, 2024, Raymond James Investments, 7251, James Sowell and Company, 401k, 6817, Raymond James IRA, 2106, and WRS Capital Partners, LLC. That's what the, oh, and memberships, miles, rewards in husband's name, and all other separate property in husband's possession. The court didn't reference Exhibit 1A at all.
In the property issues, Your Honor, it just says all separate property issues in husband's possession. It says that for both husband and wife in that section.
Correct, but I specifically said under wife's separate property, household items, household property items set forth on Exhibit 1A. I didn't say.
I see what you're saying. Yeah, so if Section 7 comes out and we attach 1A, I think that will fix that.
Okay. All right, are you finished with page 36 or are we on page 37?
Page 37, Your Honor,
Okay,
and I simply have to ask, we listed reimbursement claims, and I'm not sure if any of my clients' reimbursement claims were recognized. And so we left a section here as a confirmation, the separate property. That's what Mr. Brian Rice, our expert, testified to at trial.
it's listed on the spreadsheet. It specifically says include $147,785 reimbursement to H's estate.
Yes, Your Honor, and I think my response to that would be, I don't have an objection. I put the money in as being awarded to husband, but I didn't specifically include language saying that a portion was that was because of a reimbursement claim. And I don't necessarily have an objection to us doing that. I just, for some reason, didn't include that specific language, but I did include the actual asset as being awarded to husband. So if we wanted to put in a separate section that the reimbursement claim was considered by the court and was an offset property value was awarded to husband, that I don't have an objection to that.
Okay,
yeah.
This is what I'm going to do because the rest of page 35 is blank. I'll just add the reimbursement language at the bottom of that underneath number 7. Is that what you're referring to, Attorney Lovelace?
Yes, ma'am. That was one of many reimbursement claims. And I see now in the spreadsheet, it says includes 147,785 reimbursement to husband's estate.
Right.
I didn't know there was anything else that was listed here as a reimbursement claim.
Well, what your client testified to at trial, whatever he testified to in those amounts, that's the reimbursement.
Well, it was a lot more than that he testified to at trial.
That's what the court found in terms of the reimbursement. That's what the court awarded based on the testimony.
Okay.
So, let me see. I'm writing out the language and you all, I will need your assistance on this. Hold on. It is ordered. Or the court finds.
So, Your Honor, this is another question I have. I'm sorry. Normally, if we identify what's separate and community, I don't know where the reimbursement is coming from. If we group the Sal 401k as community and separate as whole, it normally would come out of the community section only.
You're referring to was written off to the side because it was.
I'm just referring to that on the share screen I pulled up. It says husband's 401k. At the top, it says value. It has husband's value, wife's value with no differentiation between separate and community. And then the reimbursement claim appears to pull money out of the whole instead of differentiating that it's out of the community only. We don't normally take money out of the separate to pay the community. So that would be something, I'm not sure how to draft that.
Well, Your Honor, the way that if I may, sorry to just jump in, but on page 25, if you look at property to husband, paragraph 4, little a, and wife's proposed order, that is the account wherein the court included that reimbursement amount. So I would be fine doing under little a, the sum of $449,012 from husband Sal and Co. 401k ending in 6817, and then adding a comma, which amount includes recognition of his reimbursement claim in the amount of $147,785.
Okay, you're going to have to repeat that because I was at the bottom of page 30.
Okay.
So we're back on page 25.
Yes, Your Honor.
Okay, and which one?
And little a,
Okay,
and saying comma, which
on little a, so the semicolon or a comma?
either one, probably a comma. I would use a comma.
Okay,
Little a that says comma, which includes recognition of husband's reimbursement claim awarded by the court in the amount of $147,785.
which includes recognition of husband's reimbursement claim awarded by the court in the amount of $147,185.
$785. I think, sorry, I'm squinting.
Hold on, I have it right here. 147,785.
Yes,
Okay. I think that satisfies the reimbursement language. Is that right?
I guess my question still is there as to the community and separate portions of that account.
Okay. We are now on page, I believe the court has already addressed it twice. So we're going to keep going forward with the entry. I believe we left off on page 35. Now we're on 30. Well, we were on 36. Any other objections on page 36?
I did have one objection, Your Honor, that I neglected to mention earlier. In the spreadsheet and in the ruling, Ms. Shrammy has her business known as Stage Collective. And I'm trying to make sure I tell you the right thing. Her credit card debt is awarded to her for Stage Collective, but it's also included as part of the overall value of the business. So the court adopted the value of 313, which included all of her credit card accounts and bank accounts. But then the court, due to Ms. Bowman's spreadsheet, also included the credit card of the business down below as personal debts of the parties. And that's something that is reflected on the court's ruling that I want to make the court aware of.
and Your Honor, my response to that is the same as it was in then. We had separated apart the Stage Collective debt from the Stage Collective asset. We were arguing the Stage Collective asset was valued at around $250,000. Husband was arguing it was valued much more. We had included the debt separately because that was a firm number that no one could really argue about. So by including the debt separately, it doesn't change the asset value. So I don't, our version of the decree on those issues accurately incorporates the memorandum ruling, and the court went with the larger number asset value. So I'm still unsure what husband's even arguing about, but I do believe that our decree accurately incorporates the court's ruling on the debt as well as the asset being awarded to wife.
Okay, and I don't see the discrepancy with the memorandum and the order that they've prepared thus far in terms
Sorry to interrupt, Your Honor.
in terms of the amounts.
Well, they gave you a spreadsheet that made it look like it was her personal debt, even though it was a Stage
So I
Collective
object to
credit
that
card.
being relevant and assuming facts not in evidence.
Sustained. Again, we're not reopening evidence, and you can, like I said, Attorney Lovelace, I understand your client's position. He doesn't necessarily agree with this, but that's not what this portion is for. This is simply to get the order entered. We're on page 37. Any objections to page 37? This is the federal
No.
income taxes for year of divorce.
Not for 37.
Okay, 38.
Because the parties are 223 possession and no child support, we simply ask that they alternate who gets to claim the children as dependents each year, just to make it easier so we don't have to come back on this on another day.
Attorney Bowman?
Yes, Your Honor, I don't think that was requested by husband at trial. It certainly wasn't any evidence that the court considered at the time of trial. And so I think that's just an issue they're both going to have to deal with separate and apart with the IRS as to who gets the dependency exemption.
And it's my understanding that the court does not have any jurisdiction anyway to make that designation unless there's an agreement between the parties. So absent an agreement, that's an issue with the IRS.
Yes, Your Honor.
Okay, so it looks like we satisfied all of the issues in terms of related to what the decree says. So what I'm going to do is, I know this was, I'm doing the organizing page, and I'm taking out that last signature page and just leaving my signature page.
Yes,
But
Your Honor.
it's made all of the adjustments. See on May 30th. I'm just reviewing to make sure that, and I'm going back and removing these hanging headers. It's a personal thing. I just don't like hanging headers. And it was my fault that it's like that, so.
And Your Honor, I think my clients referenced that the parties did have an agreement regarding the tax dependency. I'm trying to see where that would be.
I mean, I don't remember it being in any of the stipulations. I could be wrong. I've slept since this trial, but I don't remember seeing anything related to an agreement about the taxes.
And I'm trying to find it for Your Honor.
Okay. Let's delete this.
Well, and I'm being told by my client that she did agree that each party can take one child per year, that husband will take Olivia and she will take Warner.
Which I think was the language we put in there, Your Honor.
Is that the language that's in your?
Let me see.
On page 39, we put wife shall claim Olivia, husband shall claim Warner.
Okay, hold on.
Oh, sorry, I have it backwards as far as the agreement, but I think this must have been something they discussed separate and apart from trial stipulations.
He has Warner in 2022. And I think they already filed for 2022 as well, Your Honor.
Okay. So, Attorney Bowman, where is that listed in the decree?
It is not
wasn't.
listed in the decree. I think, Your Honor, honestly, I think that should just be something that they work out amongst themselves since it wasn't in the court's order and we can't seem to agree on who's taking what child. So I think they can always work out amongst themselves any agreement separate and apart, but for purposes of a decree entry, I don't believe that's something that
And Your Honor, it's funny that both clients are texting their attorneys saying we have an agreement, yet Ms. Bowman saying we don't need to include it. I'm trying to simplify it and knock out as many issues as we can, because that's what the parties want to do.
If it's an agreement, because they really did do a good job, I was impressed by how they were able to agree on majority of the issues related to the children. I don't see an issue with putting it in the decree if they both agree that that's how they're going to handle the tax liability.
yes, Your Honor, I'm texting to get clarification because I'm a little confused about that.
Okay,
We agree, Your Honor.
okay. Now I'm trying to see where would I put it. Each party, all payments are corporate with each other. I think the best place to probably put it is right. To make it clean, I probably need to add it on page 39 before the date of judgment and the judge's signature.
Yes, Your Honor, that works for us.
That's fine, Your Honor. And I put on the share screen the language that we had proposed.
Okay. I'm moving some stuff around. Okay. What did you entitle that, Attorney Lovelace?
I didn't, we could just claim tax dependence.
Tax dependence.
Yeah, or we could call it the dependency exemption, either way.
Okay. Attorney Lovelace, would you please read that?
The parties have an equal possession schedule for the children.
To the part of it is ordered. And I'm gonna, no, so let me tell you what I'm gonna do. I'm gonna say it is ordered and agreed. No, it is agreed by the parties and therefore ordered. It's agreed by the parties and therefore ordered. Okay.
That each party shall claim one child as a dependent on their taxes. For the year of the divorce and each year thereafter.
Okay.
And then it's period. Wife shall claim Olivia Schramme and husband shall claim Will Warner Schramme is what I have on the share screen.
Okay, it is agreed by the parties and therefore ordered that each party shall claim one child as a dependent on their taxes for the year of the divorce and every year thereafter. Is that correct?
Yes.
That's fine, Your Honor.
Wife shall claim Elizabeth Schramme and husband shall claim Warner Schramme.
Yes, Your Honor.
I think Olivia, yes, that's, okay, sorry.
Did I say Elizabeth?
I think so.
That's what's reading over there side. Olivia. And so the record is clear, it's Olivia Schramme, not Elizabeth.
Yes, Your Honor.
Okay. All right, so the court has made those changes, and thank you both for your patience.
Well, thank you. We appreciate you getting us in today.
No
Your
problem.
Honor, may I ask one final request?
Yes.
Your Honor, these people are cash poor. They've got a lot of assets with the two properties and their two businesses. My client lost his job. The amount of money that in which he has to pay of $699, $293 within 30 days of the ruling with interest accruing is impossible for him to pay that amount unless he starts
And
liquidating accounts.
I object again to this not being part of the entry issue.
Well, may I
Mr.
finish real
Fleming
quick?
had
Ms.
also-
Bowman?
well, my objection is to relevance and.
And Your Honor, I would
listen.
simply ask that if the court is inclined, which I know it already is, to make a payment, that the court give him a little more time or the ability to make payments instead of doing a lump sum of $700,000 within 30 days.
And Your Honor, again, I object. That wasn't the court. The court's ruling was that he should have paid it by July 7th. And he has the ability to pay.
He doesn't.
And he's already threatened to file an appeal and file a bond. He keeps
Objection as to
filing a
relevance.
bond.
We,
No,
we have talked about doing a bond, Your Honor.
Hold on. Joey cannot get both of you speaking. So this is what we're going to do. The request is denied. The court found that Mr. Shrammy has access to the money that he was ordered to pay. Now, whether he has the cash on hand or not, that has nothing to do with the court. The court found that Mr. Shrammy does have access to the assets, which is why the order was made for him to pay that lump sum of money within the time that was given. And I honestly, I think it would have been, maybe the court would have been inclined to entertain it if July 7th had not passed and Mr. Shrammy needed more time then after receiving the ruling. But now that we're at the entry stage and to ask for more time, I don't believe the court is inclined to do it at this point. July 7th has already passed. The court has signed the order. I was hoping to get it back to you all before 4:30. That's when the clerks were leaving, so you could get a copy of it back to you because Destiny has already left for the day too. So I am entering the order with the adjustments that the court has made.
I don't believe, Your Honor, that any party has submitted an affidavit for prove up or that we've actually announced on the record the requirements to finalize the divorce today, Your Honor.
You all testified at the trial.
We did.
And the divorce was granted. So a prove up is not needed.
Okay.
So the court has signed the order and you all will receive a copy of it on tomorrow.
Thank you, Your Honor. We appreciate you.
Thank you, Your Honor.
Thank you. You all have a good day.
You too.
You too.
Bye.
You won't believe it, but I literally wear.
All right, Joey, are you ready? All right. Yes, I'm connected. I can see you. All right, we're on the record in cause number DF 2304423. Counsels, will you please announce for the record?
Chris Cantu on behalf of Ebby Maida.
Thank you.
Nicholas Smith on behalf of respondent Katrina Shaw.
Thank you.
Justin Gale, AG's office.
Thank you. And just so the record is clear, the respondent in this case, Katrina Shaw, she was noticed to be here today for final trial, and she is not present. And counsel has represented to the court that he doesn't know where his client is and was informed that she would not be here today. Is that correct, counsel?
That's correct, Your Honor.
All right. So prior to going on the record, we noticed that there was a de novo appeal filed, a request for a de novo appeal filed, and it was set week after next, which is after the trial setting for today. And both counsels have agreed to go ahead and have that appeal conference today. Is that correct?
Correct, Your Honor.
Yes, Judge.
All right. So in review of the appeal conference, it looks like there was an appeal, Mr. Smith, by your client on petitioner's motion for a protective order as a discovery sanction. Is that correct?
Yes, Your Honor.
All right. So let me get the clock going here for you all. And before we start, did you all submit any exhibits for that yet? Or is that what the conference was going to be for?
I would assume that was what the conference was for.
So the conference, Judge, was your exhibit conference for trial, which only I showed up to. So I submitted my exhibits and Judge Lee said my exhibits are admitted and nobody else was there.
Okay.
And then we noticed that there was the conference that was set on November 3rd and said, she was like, oh yeah, definitely bring that up to Judge Bailey because she didn't understand why that was after the trial as well.
Okay. All right. So I'm going to give you all 10 minutes aside for argument, essentially, because I don't have any exhibits for the de novo appeal. And Attorney Smith, this was your client's motion, so I will start with you.
Thank you, Your Honor. Your Honor, we filed the de novo appeal in regard to the motion for protective order that was presented by petitioner in response to our service of discovery. There was a hearing set on August 28th, 2025 for the motion for protective order. We received notice of the associate judge's ruling on September 2nd and filed our de novo appeal on September 5th, which would make it timely filed in accordance with Family Code 201.015. The reason why we appealed that de novo conference, or that or filed the de novo in response to the protective order ruling, is because the protective order, or the motion and the subsequent order on the protective order, served as a sanction against respondent rather than issuing a protective order in regard to the discovery served. Texas Rules of Civil Procedure 192.6 permits a party to seek a protective order in regard to discovery regarding the time or place of discovery, or to protect the movement from undue burden, unnecessary expense, harassment, constitutional property rights, any of those things. None of those were alleged in the motion for protective order. If the moving party demonstrates that protective order is necessary, or that the discovery sought creates an undue burden, unnecessary expense, harassment, etc., the court may issue rulings in regard to that discovery not being able to be sought in whole or in part, ruling against the discovery having to be answered, limit the discovery that's been served, or the discovery not be undertaken at the time or place specified, or the discovery be undertaken only by such method or upon such terms and conditions, or at the time and place directed by the court. Per the rules of civil procedure, there are no means for the court to sanction a party in regard to a protective order, to strike a party's pleadings in the entirety of the case in regard to a protective order, or issue attorney's fees in regard to that protective order sought. And all of that, I believe, was done outside of the scope of the permissible rulings that could be undertaken by this court in regard to a protective order against discovery. And that is why we had served our notice of de novo appeal in this, Your Honor.
Okay.
This is one of my favorite little gifts to give. I love how it looks so
Attorney Cantu?
Yes, Judge. So I guess I'll just begin with 192.6, which is the motion I filed for a protective order, which clearly states that anybody who served discovery may move within the time permitted to respond to that discovery and request protection for that person from the discovery sought. That is exactly what my motion laid down. And it's interesting for Mr. Smith to say, well, his motion didn't say any of that. Judge, I would just like for you to take judicial notice of the court's content and file in my motion, which lays down exactly why I filed it, including the injustice that has been served on my client from a mom who has removed these kids from Texas, their home state, for over 1.5 years, and then thinks that she can be ordered by this good court to appear to court several times and not do it, and then think I should be able to serve discovery shortly before trial.
The court takes judicial notice of all contents of the court's file.
Thank you, Judge. In there, in the motion itself, to protect my client, the judge only has to see if whatever happened during this case has been harassing, has been burdensome, has been inappropriate. She can consider all those things. And to protect my client from any undue burden, any unnecessary expenses, which I believe would be extremely unnecessary expense for this mom who didn't even show up today to say, I need to serve discovery when I don't listen to the court. Anyway, we had a hearing on it, Judge. And under Section B of 192.6, the court may make, this is very important, it says the court may make any order in the interest of justice and may, among other things, order that the requested discovery not be sought in whole or in part. Again, one of the things that the Judge Lee could do was stop the discovery, say you can't serve any discovery. She may do any order, that's what it says under 192.6 under protection orders, the motion I filed. She may make any order in the interest of justice. When I presented my motion and counsel didn't show up, his client didn't show up, I presented the evidence of what was been going on in this case, and Judge Lee saw fit to order exactly what she could order. No discovery, attorney's fees, which in family law can be ordered for any motion. It's in our code, and to strike pleadings. The other problem with this is counsel is arguing that she struck pleadings, but they have no pleadings. They've never filed any motion, or I'm sorry, any pleading, any petition, any modification. They've never had any pleadings for over a year. So I guess the argument is, even though we didn't show up, we would like for you to overturn what Judge Lee did, even though it was in her power to do it, Judge. So I believe that this de novo should be denied. Judge Lee had the power to stop their discovery, to order attorney's fees, and to sanction her for trying to use discovery, even though she has not been cooperating with Judge Lee's orders. That's what I presented at the motion. And that's what at the hearing, and that's what Judge Lee considered. And so yes, Judge, this de novo is kind of ridiculous. And once again, the respondent's not even here. So somehow to say that that's affecting their trial, that had no effect on them being able to present exhibits or showing up to any motions or showing up today or showing up to the exhibit conference and then trying to introduce any exhibits. That has nothing to do with anything. And they've never had any pleadings on file.
Thank you. Mr. Smith?
Nothing further, Your Honor.
Okay. The court does have a question. There was an order for substitution. I did just sign it. I want to make sure I state that for the record. I did officially just sign the order of substitution of counsel that was filed way back in like March or April of this year. Since you have been on the case, why haven't you filed any pleadings?
I can't answer that, Judge.
Okay. Excuse me. Has your client, well, I mean, without violating any type of a current attorney-client privilege, is it your understanding that your client does want to participate in this case?
Yes, I would say it is my understanding that she does.
Okay.
But arguably from actions, I think that might be a little different.
All right. Okay. So anything further?
Nothing further, Your Honor.
All right. So the court is going to deny the de novo appeal. So we've taken care of that. In regards to the trial setting for today, counsel, Attorney Smith, I noticed that you did file a continuance for your client.
Yes, Your Honor.
However, based on review of the court's record, client's behavior, it would not be in the best interest of justice to delay this trial any further and give these parties some relief. Because if the court is under the impression that if I reset it, we will be in the same circumstance again.
Yes, sir.
And I don't think that's a good use of anyone's time. So the exhibits that I have from Dad are exhibits 1 through 16, and they are admitted. And it's my understanding that your client has not presented any exhibits.
That's correct, Your Honor.
All right. So, sir, would you please raise your right hand? Do you swear or affirm that the testimony you'll give today will be the truth and the whole truth?
Yes.
Okay, thank you. We are set here today for a final bench trial on the suit affecting the parent-child relationship. You all are set for 30 minutes aside. You may give any opening statement and any closing statement should you choose to do so. However, that's totally within your discretion. But it will include any examination that you do as well. And State, I'm setting your clock as well. I know you're standing over there, so I don't even know if you, is there any objection for the state to go first?
No objection.
No, Your Honor.
Well, Judge, I'd like to raise some important question that I realized this morning. So this did originate on the state's motion to modify the confirm arrears. Parties had an order a couple of years ago that did not set child support because parties were living together. There was medical support order and government health order at that time. There was a temporary order during the litigation that set father's child support to 280 or 89, I believe. And that was on in October of 2024. After review of the OAG system, that temporary order was never sent to OAG by any. As such, I do not have a current accurate pay record as to any arrears father may or may not owe at this time. The medical support that was ordered prior to this litigation has stopped because the temporary order ordered mother to carry private health. So there's no current medical support at all. He does owe a little bit, which came from a couple of years ago. So my point is, there's no current pay record. Ordinarily, I would provide one as an exhibit for arrears. I don't know if father's been paying mother directly, and she's not here to ask about that. Since we're proceeding today, I have no problem with the state simply non-suiting its request to confirm arrears, which worst case scenario, father hasn't been paying his child support arrears would be 289 times 11 plus some interest, so not a whole lot. And the state would just proceed to confirm arrears in 4D later, unless there's something that I don't know the parties know.
Just briefly on that, Mr. Dale is correct. So in October, what happened was that was when Judge Aguilar asked her to come back. She didn't. So she actually was ordered to pay child support in that October order.
And I was looking at that. We're referring to the order that is, it's like 32 pages long.
20, I have it at 29, Judge, on, yeah. She was ordered to pay 289. And it was signed by Judge Aguilar on October 17th, 2024.
Okay.
And it was Miss Phillip that was on the case at that point. She appeared too. So it was mom that was ordered to pay child support.
Yes, excuse me, it was mother. Even so, Judge, the state would like to not request to confirm father's arrears today, as there is minimal medical support arrears, and is happy to proceed on the child support issue only.
Okay.
Thank you.
You're welcome. The court accepts that request. Attorney Dale, are you going to give me an order pursuant to that, the non-suit?
I would typically, I can just include that language in the final order.
That'll be good. Okay, thank you. All right, so the issues that the court is proceeding on today will be child support, possession and access, conservatorship, and attorney's fees.
Yes, Judge, on our end, yes.
Okay, all right.
And I'm sorry, Judge, just a brief opening if I may. I know I don't.
Sure,
I know I
go
don't have
ahead.
time, but yes, just this has been I believe the evidence will show, this has been a very difficult case for my client. This is a case that started in 2024. Mom absconded with the children, appeared and told Judge Aguilar that she was going to come back. We reset, she doesn't come back with these kids. All the while, my client's not being able to see his two kiddos. We get in front of Judge Lee for a pretrial. Mom appears via Zoom on that one. Judge Lee orders her back because we have stand live pleadings over here. which is part of our evidence to show that there was temporary orders that she would not obey. Judge Lee told her to give her a week to come back. Instead, she sends an attorney. The attorney says, I don't know where my client is. So Judge Lee, we again reset, says she needs to come back. At that point, in between the reset, we learn of a Philadelphia case that mom tried to start. And the evidence will show that after a judicial conference, which is under P2, I included the order from Philadelphia, wherein that judge found that the mother was lying to her and she dismissed all of her cases and was once again told to come back to Texas. My client at this point still hasn't seen the children, and we're getting into 2025. We set 3 more hearings, Judge. Another attorney appears for her. She has not appeared. The evidence is going to show that my client has paid me a lot of attorney's fees to get these orders done, to try to get mom for a sheriff to remove these children from Philadelphia, but she was too difficult to find to come back. So today, Judge, we believe with the evidence that we're going to show that this court needs to find that Texas is the children's home state. My client needs to be sole managed conservatorship. Mom should have no visits or supervised visits, and should have to pay a bond to secure any possession access. This is one of those rare cases, Judge, that it doesn't matter what any court tells her, she's not going to listen. We need an order with teeth so we can get the right authorities involved if need be. I will say that luckily, my client has told me the kids are back. They're actually with him, and he wants an order so that way this can't happen again. He is finally able to see his 2 girls. We brought pictures of them together recently. They're going to a school right by his house. Just sheer luck, not because she was arrested and the kids got back. He has the kids back. She brought them back, and we need an order so this cannot happen again. And once again, Judge, she's not here. So there is a concern that none of this matters to her, and we need the court to have a strong order, which we believe through our request for relief and our proposed parenting plan is in the best interest of the children. Thank you, Judge.
Thank you. Attorney Smith?
I'll waive opening, Your Honor.
Okay. And Attorney Dale?
I'll wait.
All right. Attorney Cantu, you may call your first witness.
I call my client, Mr. Maida.
Okay. Mr. Maida, if you'd have a seat right here, you can just come this way. And make sure you see how the microphone is right here on me? Make sure you pull the microphone close to your mouth.
My wife can't stop staring at me since I started wearing these pants.
There you go. When you're ready, counsel.
Thank you, Judge. Mr. Maida, your name for the record, please.
My name's A.B. Maida.
And we are here talking about your 2 kiddos, Sienna Shaw and Everly Shaw, correct?
Yes.
And what are they, 9 years old and 6 years old?
Yes.
Prior to, I know recently the children are back living with you, correct?
Yes.
And has that been amazing?
Yes, it has.
How long had it been since you had seen the kids?
A year. A little over a year.
Throughout the pending, you heard my opening, you've heard what's happened. Is it true that at least since July of last year, maybe even a little before then, you hadn't been able to see your kiddos?
No, not at all.
And is it true that on 2 different occasions, at 2 different hearings, Miss Shaw, the mother, appeared and stated she'd be bringing the kids back?
Yes.
Is it true that we've had several orders for her return to bring the kids back?
Yes.
Throughout their lives, their young lives, has Texas been the only place where they had actually permanently resided?
Yes.
What we have already pre-admitted as P1 is your requested relief. Today, you're asking the judge to actually grant your proposed parenting plan, correct?
Yes.
Your proposed parenting plan, as what has been pre-marked as and admitted as P16, lays out conservatorship, possession access, and child support, correct?
Yes.
In there, specifically, as Judge Lee and Judge Aguilar have already ordered, it orders you as the sole managing conservator, correct?
Yes.
And as Ms. Shaw as the possessory conservator, correct?
Yes.
Do you believe that, and you see that Ms. Shaw is not here again, correct?
Yes.
Do you believe it's in your best interest of your children for you to be the sole managing conservator of these kids?
I do.
Do you believe that mom's behavior this last year and a half of absconding and keeping the kids away from you, was that good or bad for your kids?
That was bad, terrible.
And you do realize that she tried to file lawsuits in Pennsylvania, correct?
Yes.
And you had to pay me to find her lawyer, find what court she was in, and ask for a motion for the judges to confer, correct?
Yes.
You participated in a hearing with the judge from Philadelphia, Ms. Shaw's lawyer from Philadelphia, and Judge Lee, correct?
Yes.
And after all the evidence was presented, it turns out that there was no proof of mom living in Philadelphia longer than a couple months, correct?
Yes.
In fact, you've had pictures of you guys living here in Texas for the last 3 years.
Correct.
In this requested relief, you're asking to be for the judge to find that the home state of the kids is Texas, correct?
Yes.
You are also asking for the judge to find that there is credible evidence of Miss Katrina Shaw abducting and absconding with these children as she's done in the past, correct?
Yes.
You want the judge to find that she has previously disobeyed these court's orders, correct?
Yes.
You want the judge to enjoin her from hiding or secreting the children, correct?
Yes.
In our request for relief in this proposed parenting plan, you're also asking that she be prohibited from herself or anybody in concert with her removing these children from Texas and the United States, correct?
Yes.
And you're requesting that Ms. Shaw execute a bond of at least $10,000 in case you have to, once again, try to locate her and get these children back to Texas, correct?
Yes.
You are asking for Ms. Shaw's visits to be supervised at Hannah's house on the second Saturday of each month from 10 to 2, correct?
Yes.
Or for the court to order what the court believes would be a visitation for the kids and mom that would be in the best interest of the children, correct?
Yes.
You would also like a permanent injunction against Ms. Shaw from removing the kids from any schools they're going to, any daycare facilities they may go to, correct?
Yes.
You are asking for Ms. Shaw's child support. She's was ordered back in October to pay you child support. Has she paid any child support since October?
No.
You are asking for the court to order her to pay child support based on minimum wage and for her to be paying $294 per month with the first payment due November 1st of 2025, correct?
Yes.
And then after your eldest ages out per the Texas Family Code, for that to drop down to $234 a month, correct?
Yes.
Besides the security bond for potential risk of international abduction, you would also ask that prior to mom executing any visits that the court may award her, she post a cash bond with the court of $5,000 so we can ensure that she understands that these orders should be followed, correct?
Yes.
Look at this. Just look. If this had come out a few years earlier,
And we are also asking that you apply for some kind of medical care, whether it be through your job or through the state, within 30 days so you can get these kids on medical insurance, correct?
Yes.
And that mom pay cash medical support, which has been laid out in our proposed parenting plan, correct?
Yes.
What school are the kids going to right now?
They are going to Uplift here in Grand Prairie.
They're like in school?
Yes.
Did they start on time?
Yes, they started on time.
We have what has been pre-marked as P9 and P10 and pre-emitted pictures of their room that they have at your house, right?
Yes.
And you have what your mom, who lives with you besides your kids? Your mom?
It's like it's two different houses. So like our house is in the front, theirs is in the back. So I mean technically, yeah.
Okay,
They-
so
they
your
live-
mom's there, so you have help.
Yes, yes, I do.
They love grandma.
Yes,
They got a good relationship with her.
yes,
And then you just recently were reunited with your daughters. You have some pictures, which were pre-marked as P10. That's recent pictures of you and your daughters at the house, correct?
yes.
Happy to see their dad.
And they were very happy.
What's been pre-marked as P13 was the order to return that Judge Lee signed. She gave the mom about a month to return these kids and then finally signed an order to return them, correct?
Yes,
You were present at the hearing, the pretrial hearing, where the mother, told Judge Lee she picked a date and time that she'd be back with the kids. Do you recall that?
yes,
Judge Lee reset the hearing. Did mom appear at the date and time she said she was going to bring the kids back?
no,
Instead, she sent a lawyer, correct?
yes,
His mom appeared. We've had 5 settings in this case. Has mom appeared at any of these settings?
no,
Do you have a fear that if you don't get an order with the requested relief you have, that mom can just take the kids again?
yes, I do.
Do you believe that this order would give you enough enforceability to ensure at least a better shot at getting these kids back if mom were to abscond with them again?
Yes,
Sir, in here, under your requested relief, you're also asking for the court to confirm that Ms. Shaw owes $2,023 in child support arrears based off of the October 2024 temporary order signed by Judge Aguilar, correct?
yes,
You're asking the court to confirm that arrearage and grant it as a judgment against her and in favor of you, correct?
yes,
In here, you've laid out a payment amount, a date, time, and location for mom to pay it in your requested relief, and you're asking the judge to grant that as well.
yes,
You also want the court to confirm that through the temporary orders and sanctions that Judge Lee has assessed against Ms. Shaw, she owes $3,000 in attorney's fees, correct?
yes,
That's already been ordered. You're asking the judge to confirm that amount and make it a judgment, correct?
yes,
And that's also in your requested relief under relief request number 3.
yes,
Sir, throughout this case, you have had to pay, aside from the $3,000, not including the $3,000 that you're asking the judge to confirm, $20,570 for the 6 hearings you've had, correct?
yes,
For trial, correct?
yes,
For the motions, and one of them being with a judge in Philadelphia, correct?
yes,
You have paid my office. You've worked hard for that money, correct?
yes,
And you're asking the judge to grant you an attorney's fees judgment in that amount.
yes,
And you're asking that to be awarded to you and against Ms. Shaw for $20,570, correct?
yes,
Do you believe that your requested relief and your proposed parenting plan are in the best interest of your 2 children?
I do.
I'll pass the witness, Judge.
All right, Attorney Smith.
No questions, Your Honor.
Okay, Attorney Dale.
Mr. Mayor, you're asking that mother be ordered to pay your child support based on the wage, correct?
Yes,
You know, do you have any personal knowledge of whether or not she's employed currently?
she's currently working, I believe it's a daycare. I think the name of it's called Little Rascals. Yes. I would say maybe at least 2 months or so. Well, I've been to her job before, so other than that, and I mean, I've seen her paychecks, and I mean that's it.
This is the last time you went to the job.
About a month ago, I went there to pick up my daughter.
I never thought looking cool at 72 would be possible, but these
And she wanted to show me how much she made. If I had to guess, I'd say like maybe 4 weeks ago, around that time.
You recall
I believe it was 1,300.
pay period, how long she stayed?
It's every 2 weeks.
So you know, she has the other,
No.
that for net income, right?
Yes, I believe so.
What kind of funds?
They have Molina Healthcare. No, I believe her job, I think, provides. Yes. Probably around 2 months or so, like when she first got the job. Yes.
You have credit cards?
No, sir, not on me.
Well, has she provided that
No.
since the girls have been living with you at the doctor,
No.
you providing her girls health insurance is gonna be in this final quarter. Are you asking that she be ordered to continue to maintain this health for her job?
Yes.
And do you have any idea of how much that costs her this monthly grant?
I have no idea.
Know where she's working, what they do?
Before this, she didn't have a job here, so it was somewhere over there in Pennsylvania, but I forgot what it was called.
Where's the daycare?
It's here on Crocker Hill.
Would you like her to pay other job based on $1,300 every 2 weeks as for
Yes.
Are you currently employed?
Yes, I am. I work for my dad's company, actually. It's a trucking company. He pays me by the load, so it depends how many loads I do a day. 500.
To employee or
1099.
do you have any other?
No.
All right. Attorney Cantu, anything further?
Just briefly, based on Mr. Dell's questions, sir, in our proposed parenting plan, it stated that you apply for insurance, but you would like to modify that and ask that mom continue to maintain these children on Molina, correct?
Yes.
And that it states to base her child support off of minimum wage. However, if the calculation is based off her income information that you provided, you'd be okay if that's what the child support calculation would be, is based off her income that from the evidence you provided.
Yes.
Other than that, the proposed parenting plan, other than the child support and health insurance request that you just modified right now, the rest of the parenting plan you're asking to be granted in full, correct?
Yes.
I'll pass the minutes, Judge.
Okay. Sir, I have a question for you. In your proposed parenting plan, you recommended the court ordering her to have supervised visits at Hannah's house.
Yes.
Would you also like for it to for her to be responsible for the cost associated, or are you going to be associated with those costs?
If she can help out a little with that, that would be appreciated.
Okay, thank you. That's all the questions that the court has. Anything further for this witness?
Nothing further for this witness, Judge.
Thank you. Sir, you may return to your seat next to your attorney. Attorney Cantu?
Choice Home.
I guess just briefly call myself on attorney's fees.
Okay, go ahead.
Thank you, Judge. I've been practicing law for about 8 years now in the Dallas-Fort Worth area. This has been a case that didn't have to be as difficult as it was. We were hired on back in 2024, initially for a modification case. We charge our clients by tasks, but we do have hourly rates. Willie actually appeared for the first hearing in front of Judge Aguilar, wherein the problems started, where mom had already left, absconded, and then was told to come back. At that point, Mr. Meda had to pay us additional fees past the one fee that we thought he was going to have to pay. And we had a reset hearing in October, which I appeared, mom didn't, and we had a default hearing. We then had a pretrial that he paid for, that we appeared and mom appeared. And after that, there were several hearings, Judge. I believe it's on the court's docket. We had a status hearing where mom did not show. We had a jurisdictional hearing with courts in judge in Philadelphia, motions filed by my office to get that accomplished. We had to present Judge with an order for the children to be returned through a writ, which he paid me to file and execute. We had 3 different temporary orders set, 2 of which had to be reset because I simply wanted mom to appear or her attorney to appear. They wouldn't. We finally had to take another default on May 27th of 2025. We appeared for a pretrial. We had to file a motion for protective order against mom and her request for discovery in August. We appeared recently to the exhibit conference with a no-show, and we're here today, Judge. I do charge at this point $4.50 an hour. I believe my contract with my client was $2.85 an hour, but we do charge by the task. I believe with all the hearings, all the motions we've had to present, that he has paid us a reasonable fee, including trial today of $20,570, which is more than he was estimated at, simply because these kids were taken away from him, from their home, and required a lot of additional hearings, some of which did need to happen because mom was dishonest with the court and dishonest with the Philadelphia courts. So I believe that those attorney's fees are reasonable, Judge, and I'll pass myself as a witness.
Okay. Attorney Smith, any questions for Attorney Cantu?
Just a couple briefly.
Go ahead.
Mr. Cantu, you had stated that you bill your client, or your contract with your client is for $2.85 an hour?
Yes, sir.
Okay. And is that what you billed him at that rate throughout this case?
No, sir. As I stated, we have an hourly rate, but we charge our clients by the task. So in our contract, each motion, each trial, each appearance, there is a estimate of what it will cost, and that's how we charge our client. But for purposes of itemizations, breakdowns for court purposes, we have an hourly rate.
Okay. And the $20,570 that you have presented to the court today, is that based on the task structure, or is that based on the amount of hours expended and applied to the hourly rate?
The tasks, yes, sir.
Okay. No further questions, Judge.
Okay. Attorney Dale?
No question.
All right. Attorney Cantu, you may call your next witness.
I have no further witnesses, Judge, and we rest.
Okay. Attorney Smith?
We have no witnesses, Your Honor. Rest.
Okay. Attorney Dale?
State has no witnesses.
All right. I I have a question for the state. The arrears that Mr. Maida is requesting in the amount of $2,023 in child support for mom, do you have an as of date?
I do not.
Okay,
I would assume that the current. So October 22nd.
okay. Thank you. And Attorney Cantu, the $3,000 that were previously ordered, are you asking that to be added into the 20,570? Or you, because I would think it needs to be cumulative.
I think you're right, Judge. I had separated them only because I didn't want the judge to see that I had included it as a part of the attorney's fees. They were already ordered, but yes, they should be one judgment of, I guess, the 23,570.
Okay, thank you. But the 20,570 is what you're requesting be paid to your office. Well, the 3,000 is to your office as well.
I'd want them both to Mr. Maida, but I have them paid at my office.
Okay,
Yes.
I got it. Thank you.
I do want them awarded to him.
All right. Anything further?
Other than that, Judge, I do have a proposed order for the de novo hearing that I would like to present.
Yes, please.
May I approach you?
Yes. And thank you for giving me a proposed order. I like to sign those just to keep the record clean. And I'll get this turned in.
Build a website you love with Wix.
All right, so the court is going to grant father's request in father's proposed parenting plan. The court grants it in its entirety. The court would also like it to be added that mother shall be responsible for the cost, solely responsible for the cost with supervised visits at Hannah's house. The amount of attorney's fees is granted to, that's a cumulative judgment in favor of Mr. Maida in the amount of $23,570.
Ouch. Ouch, ouch, ouch.
The court is confirming their judgment. The court is also confirming the judgment of child support arrears in the amount of $2,023 against mom as of October 22nd, 2025. And the court accepts the agreement, the payout rate that was recommended to the court for mom to satisfy that judgment. Is there anything further?
No, Judge, I assume I will do the order, so I just will make sure I get it out to Mr. Dale and Mr. Smith.
Okay, and about that, how much time do you need? I can go ahead and set you on a dismissal / entry date.
I would prefer if we could, Judge, the last week of November. I know that's Thanksgiving, but I do have paternity leave coming up. I could do it by November 24th.
Okay. Let's just do this because
That's tomorrow.
the 28th, that coming up Friday after that is a holiday. So let's push it to December the 5th. So of course, if you all get the order to the court before then, you don't have to worry about that date. But in the event that you don't, you have to show up to that date. And the dismissal docket is before Judge Lee. And her Zoom code is 961-1106-4392. That's in the event you need it. You all may not need it.
Thank you, Judge.
All right. Thank you so much for your time.
Thank you.
Thank you. We're off the record.
And guess what? We are off the record. Yeah, I agree with that, John. So she's trying to avoid it. That's it for today, ladies and gentlemen. Now, Thursday, any days that I can get off, I'm taking Thursday off. I'm taking Christmas Day off. I'm taking New Year's Day off. I have a doctor's appointment in January. I'm taking that day off. Any little days that I can take off, I'm going to take off. You know, I've been doing this nonstop since I started this channel, so I need to take a break for a while. So I'm looking forward to Thursday. I'm not getting up. I'm going to sleep in. But to everybody, all right. So if you like this content and you like this kind of content on this channel, please do me a favor and help the channel grow by subscribing to my channel and hitting that like button. That's it for today. I will see you guys tomorrow at our regular time. Ta-ta, ciao, and have a good rest of your evening.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right when I'm falling apart. You put me back together. You make it better. From the wires tangled up to the broken dreams. You know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright when I'm falling apart. You put me back together. Daniel, you make it better. Make it right when the world shuts down and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, now I'm standing tall to